Um, Thought maybe you were gonna research the number. Cause this the number we went in on the last time. All you had to do was pull that up, and that other number up under there was the dismissal number. All you had to do was go back in there, call it like we did on the computer. That was the number we used the last time. And then this would have been the dismissal number. Remember, we were putting the numbers in wrong. That's because we didn't have it like that. But I found this, but I don't know if this correct. Okay, you supposed to find it. No, I'm doing exactly. But no, if okay, when you call me, I'm gonna start doing exactly what. But you supposed to research the number, and because I told you I wasn't sure that was the number. Give me, let me call somebody. That ain't the number. Call this number 214-653-7375. See if they could tell you a zone number for the dismissal code. Let me. I'm gonna have to give you the case because that ain't you supposed to find. That's the 95th court. I'm really. Yeah. Let me talk. Let me talk. Hang up because we don't need to hold. No, you have to find the dismissal court. Hang up and call his ass back. No, no, because you need to talk to somebody. We ain't got that long. This gonna be some shit like we were the last time. If you had done like research numbers. Let me hang that phone up and call back and to tell him you can't afford to be on hold. You're trying to get in your zone. See, he keeps saying it to the phone. What time is it? We're probably in the 302 court. Until
Good afternoon, Sandy.
Would help if I unmuted myself.
Okay.
How you doing, Jason?
Good. How you guys doing?
Hi,
Greg.
Jason.
Hey,
Long
Greg.
time no see.
Yeah, it's been a minute. While we're waiting, I sent you guys an email about some proposed dates for pretrial exchanges. I don't know if you saw that, but do you think you guys might get back to us on that?
We plan to respond by Monday.
Okay.
All right, good afternoon, council.
Good morning. Good afternoon, Your Honor.
Good
Good
afternoon.
afternoon.
Good afternoon. Going to go ahead and call your case. We are on the record in cause number DC 22-14618, Data Axle Inc. et al. Versus Talkdesk Inc. et al. May I have you all to announce on the record for me? Let me know your name and who you represent.
James McCorkadale on behalf of Data Axle Inc. And with me is Greg Scaglione and Trevor Lee.
All right.
And Jason Yu with Orr, Carrington, and Sutcliffe on behalf of Talkdesk Inc.
All right. If there are no other announcements, I understand this is the plaintiff and counterclaim defendant Data Axle Inc.'s no evidence motion for summary judgment. Is that correct?
Yes.
All right. Let me go ahead and hear from the movement with respect to their motion for summary judgment.
Your Honor, I do have a summary document I'd like to share on the share screen, if I may, to walk you through our argument. I think it'll be more efficient, if I may.
Okay, you should be able to share your screen. Just make sure that feature is on. Yes.
Let me bring it up. Not seeing it. Let me. I'm going to try it one more time.
There it goes.
Is that legible, Your Honor?
Yes, it is. I can see it.
Very good. I'll scroll through this. I want to be mindful of your time. I know you have a busy docket. If I argue for about 10 minutes, would that be satisfactory?
That's satisfactory with me.
Very good. And I do have a couple of minor administrative matters at the very end. If we have time, I know you have a full docket.
Okay.
So I'll proceed. Your Honor, this is Data Axle's no evidence motion. We have meticulously gone through the evidence and the law in our brief, but I'd like to just summarize for you at a high level what I think is really the key issue. Unlike Talkdesk, various motions where they attacked every element of every claim, we have decided to present one and only one issue to you, and it's very narrow, and it has to do with whether the sole measure of damage which Talkdesk seeks to recover, whether that's legally recoverable or not. And the answer, both under Delaware and Texas law, is no, it is not. At a high level, Talkdesk has the burden of proof to prove each element of a breach of contract in its counterclaim. One of those elements is damages, and Talkdesk simply cannot satisfy that burden on that narrow element of damages. And I'd like to demonstrate why. We're raising this to you now, Your Honor, because we do believe it will come up in various motions in limine, jury instructions, trial objections, and directed verdicts. So we wanted to bring it to you now because we believe it'll likely shorten the instructions in the trial. So with that, I'll jump in. Your Honor, the measure of damage is a question of law, which is what we chose to only bring to you in this summary judgment. And Texas law is very clear, as complemented by Delaware law, which applies. A party cannot recover damages under a legal theory where the damage sought to be awarded does not conform to the law. Proof of damages is an essential element, and if the plaintiff fails to present evidence of a legally recoverable damage, they cannot proceed. And here's the Texas law on a breach of contract. Under Texas law, it says net profits is what is recoverable, and that's equal to the full value of the performance promised. In other words, the full contract price less the cost of that full performance. We've cited a number of Texas cases here. There are many more. We've tossed in a few Delaware cases as well. The one Dallas, Texas Court of Appeals added, the measure of damage for expectancy includes these three, but here's the key: minus any cost or loss plaintiff avoided by not having to perform this contract. Your Honor, this contract is to run till 2026, and we terminated it in 2021. So you have a 5-year contract that prospectively looks forward 5 years. And both under Texas law, and I've cited Delaware law, which also says that it's total income less expenses saved by the repudiation. So the measure is always, you have to subtract the work, the performance, the cost you would have incurred. You cannot recover the total contract price. Well, Talkdesk, its lone element of damage it seeks is lost gross profits. Basically what it does, Your Honor, and you'll see this in their disclosures to us on which we based all of our discovery. What they did is they took the gross amount of the contract price, they subtracted off $514,000 that we paid them, and they said the full contract price is what we're due. Well, that's lost gross profits. That's not legally recoverable, as I just showed you. It's also not actual damages, because you have to subtract off the cost you would have avoided to get the actual damages. But that's exactly what Talkdesk pled and disclosed as lost gross profits. They should have pled and disclosed and produced lost profits, not lost revenue. Lost profits are recoverable under both laws, but that's not what they demanded, pled, disclosed, or produced. I want to show you direct quotes because I want you to be able to make this ruling as a matter of law. So, Your Honor, here's direct quotes from their demand letter. Remember, we sent a letter out saying, you haven't performed, we've given you 7.5 months to cure, we're terminating. In response, they wrote a demand letter, and here's what they wrote in their demand letter. Instead, Data Act, direct quote, is refusing to uphold its end of the contract and thereby repudiating the MSA. This is itself a material anticipatory breach. Data Axle is therefore liable to Talkdesk for the full value of the contract. That's revenue, not lost profits. Then they ran the number. The full contract value is $2.9 million less what you paid. Thus, you owe us $2.4 million. That is a calculation of lost revenue, not lost profit. They don't subtract off cost avoided. Well, how did they present it to you in their pleading, in their counterclaim? They asked for actual damages, not limited to expectancy. And then again, you see the number 2.4 million. So as required under Texas civil procedure rules, they made disclosures. And again, we see 2.9 million pursuant to the contract, less payments remitted of 500 for a total of 2.4. So the only thing they subtracted, Your Honor, from the total contract price was our payment. They did not subtract off cost avoided. We then asked, and we based all of our discovery on these disclosures and pleadings in the demand letter. We asked in request for production of document number 27, give us the documents on which you calculate your damages. There's nothing in there on lost profits. There's nothing in there on cost or cost avoided. It is all based on what they disclosed, and that is the total contract price. So the summary of our argument that you'll find in your brief is this, Your Honor. The loan damage asserted in demands, pleadings, disclosures, and discovery is lost gross profits through 2026. Point 2, lost gross profits are not actual damages and they're not legally recoverable. Point 3, only lost profits are actual damages and legally recoverable, but they didn't demand it, plead it, disclose it. Discovery is now closed and this court declined to reopen it. Furthermore, the time to supplement or amend pleadings or disclosures has expired. So there is no recovering from this current state of the record. And the current state of the record is they are asking for lost revenue. Furthermore, Your Honor, when you ask for lost profits, there's past lost profits and there's future lost profits. And here they actually have a claim for future lost profits, or they should have a claim for future lost profits. They actually say future revenue through 2026. Well, we've cited authority for you both under Texas and Delaware law in our brief that when you're asking for future lost profits, you have to present value that back to the present. And that can only be done by an expert witness and by presenting evidence. And my point is, they presented no evidence of present value. They presented disclosed no expert to present value this lost revenue, or what it should be, lost profits through 2026. So for those reasons, the summary judgment should be granted. I'd like to cover two brief points, Your Honor, and I'll be done. I appreciate your patience. So how does TalkDesk try, now that discovery is closed, the pleadings can't be amended, and they've been called on this major defect? How do they try and get around it? Well, their first improper attempt to evade a summary judgment is they claim that once they granted Data Axle access in January of 22, that there was nothing further for them to do for the entire rest of the term of the agreement through 2026. So they didn't have any actual cost, and there were no costs to be avoided. They were just going to sit back and collect money. So they suggest that lost revenue equals lost profits. Well, on the state of this record in their pleadings, that is wrong as a matter of law. Again, I want to cite to you their admissions so you can decide this as a matter of law. Paragraph 47 of their counterclaim. Here's what they wrote. TalkDesk responded to our July 29, 2022 repudiation and by denying they materially breached the contract. TalkDesk further notified Data Axle that its refusal to allow TalkDesk to complete the implementation was itself a material breach that excused TalkDesk further obligation to perform. Right here is their admission, Your Honor. They admit that they were not complete with implementation and that our repudiation in 2022 prevented them from completing implementation. So they did have, by their own admission, further work and services, further cost incurred to complete the implementation. And by our repudiation, taking their allegations as true, we prevented them from continuing to perform their services. So this claim that we had nothing else to do, by their judicial admission in the counterclaim, is wrong. And they go on to cite in paragraph 33, they have professional services to render. Secondly, counsel on the line for TalkDesk admitted to you on the record the same exact thing only a month ago. When we were talking about asking that the hosted solution be turned on so we could demonstrate that it doesn't work, this is what he told you, Your Honor, in red. It would cost tens of thousands of dollars to reestablish and run the platform because third-party plugins that the platform uses, i.e. Salesforce, TalkDesk would need to pay fees to have third parties run the third-party plugins to utilize the platform. Well, that is a cost avoided, Your Honor. That platform was supposed to run till 2026. They say we repudiated it and breached the contract. You have to take that as true for purposes of this motion. However, here is their admission that to run the platform all the way to 2026, they would have to pay plug-in license fees to the tune of tens of thousands of dollars for the platform to run. Well, that is a cost avoided. And that cost has not been disclosed to us in any discovery. And these add-ons, or as counsel called it, plugins, they're referenced expressly in Section 5 of the agreement. They're third-party software costs. They avoid those, but yet they've not folded that into their damage claim. Furthermore, In their written response to our notice of termination, again, they say Data Axle has prevented Top Desk from completing the implementation. I'm not going to go through all of these, Your Honor, but I just want to acquaint you with a few. You can also look as a matter of law at the express language of the contract, which all parties agree are binding. It is binding. Here are just a few, not all, of the services they have to provide that require labor and or third-party software licenses. Once we go live, their consultants have to stay engaged for 3 weeks. That hasn't happened. They avoided that cost. They have ongoing services, hosting and support services for 24/7 until 2026. So there are labor costs in that. They also have to maintain the platform through 2026. They are avoiding the hosting service, the maintenance service, and they're avoiding all of that cost. Training. They did not complete all of the training. Here's a list of all the training they had to provide. They avoided most of that. Storage and use of our data. They avoid the storage cost. Cost of each user. They had to keep phone ports open for processing and to initiate with go live until 2026. And they were supposed to report to us the accuracy of that. They avoided that cost. Your Honor, this claim that all they did in 2020, that everything ended on their service end in January of 2022 by their own judicial admissions, by the contract, by counsel's statement to you on the record is absolutely false. And judicial admissions count, and the written contract counts over affidavits, which are a frivolous attempt to avoid summary judgment. My last point, Your Honor. The second improper attempt to evade this summary judgment. So I say, well, Judge, and we anticipated this was coming and put it in our brief. They say, well, Your Honor, we were entitled to accelerate the balance of the payments under the contract and then collect gross revenue. And they base that on, and they have to base it on, because acceleration can only be exercised for unpaid invoices and that they weren't cured within the time frame. So invoices are due in 60 days and there's a 30-day cure period. So they're saying we had a right to accelerate. The contract only grants that right for non-payment of invoices. Paragraph 53 utterly, unambiguously ends that argument. In paragraph 53 of their counterclaim, they tell us and you how Data Axle breached the agreement, and they list them out. Number one, we delayed the implementation while demanding out-of-contract functionality. Number two, we refused to perform its implementation obligations. And number three, we repudiated the agreement on false pretenses. There is no mention about non-payment of invoices as a basis for breach of the contract. It is not in their pleadings. It is not in their disclosure. It's not what we base discovery on. And so, Your Honor, again, now that they've spotted this defect, they're trying to go back and say, well, they breached the agreement by non-payment of invoices. That's not in their pleading. We didn't do discovery on that. So, Your Honor, they don't get to accelerate. And even if they did, even if I'm completely wrong, the fact that they could accelerate the remaining revenue still doesn't make it a legally recoverable damage. They still have to prove, even with the acceleration of all revenue, they still have to prove to you, and the jury, I should say, but ultimately to you, Your Honor, what costs were avoided. And I've shown you the costs that they were going to occur, and counsel Jason told you some of them. They didn't identify cost avoided. They didn't present value future lost profits. So for those reasons, Your Honor, we would ask that you sustain this motion for summary judgment, that I've tried to show you their admissions in the contract. This is a question of law. There is no question of fact for you to resolve. And I thank you for your time.
All right, thank you, counsel. If you will stop sharing your screen. Yes, I'll hear a response.
Thank you, Your Honor. So I think what you've heard is a gross oversimplification or mischaracterization of the law that applies here, and a overcomplication of the facts. This is probably one of the most straightforward damages cases that I've seen in a while, and it's certainly much more straightforward than any of the case law they cite. I do think that we are in somewhat agreement on the damages theory at issue here. This is not a case where we have to determine the valuation of real property being exchanged or the effect of trade secret documents or anything like that. We have a very straightforward case here. There is a contract for a fixed term and a set amount of money that is not in dispute, and partial payment by DataAxle, which is also not in dispute. This is a software licensing agreement. Talkdesk agreed to provide DataAxle with licenses to its software, which has already been developed, is sitting in the cloud, and in exchange, DataAxle agreed to pay $2.9 million. And they paid $500,000 of that, and they still owe $2.4 million, approximately. So in terms of damages, DataAxle is seeking a refund of the money that they paid here, $500,000. We're seeking the amount remaining owed, which is about $2.4 million, and that's it. And there's all sorts of evidence to support this: the contract itself, the invoices, emails back and forth, and written correspondence. So DataAxle's argument seems to be that we should have come in and had an expert opine that our damages number should be reduced for certain reasons, or offset for certain reasons by some amount. And we totally disagree with that. We don't think that's the law. First, as to the expert issue, you don't need an expert to opine on damages issues where there's not complex damages calculations. We cite a number of Delaware and Texas cases on this issue. They all say that you don't need damages experts for straightforward cases, and this is about as straightforward as they come. We're really just subtracting two numbers here. If you needed expert testimony for this case, you would need it for every case, and that's just not the law. DataAxle itself does not have an expert to come in and testify about their damages. Second, if DataAxle wanted an expert to come testify that our damages number should be reduced by a specific amount or for some specific reason, that was their obligation. They should have come in with an expert report and said that you need to offset or reduce by these amounts. That's their burden, not our burden. And even if they had done that, which they didn't do, that would be a dispute of fact. It's not an issue for summary judgment. Our position, we don't contend that there are any offsets or reductions that would need to be applied here. We had a contract. You promised to pay this amount in the contract, and you owe that amount. We gave you the licenses, and now you need to fulfill your end of the bargain and pay the amount you promised to pay us. And we cite a number of cases, Texas and Delaware, in the brief that says the full amount of a contract can be a measure of damages. I think we cite 6 or 7 cases there from both jurisdictions. And even as to the offsets or reductions that they mention, those are not incremental costs to performance. And you have to remember, this is a software license agreement. The software is already developed. It's sitting in the cloud. We're just giving you access. And we have handed over those licenses. They have access to the software. They can use it. They just need to pay the money. It doesn't cost us any extra money to perform because we've already handed over the licenses. I think counsel mentioned hosting fees. Hosting fees are fixed. DataAxle has hundreds, if not thousands, of customers. We have our hosting set up. Professional services fees. Most of the professional services were all complete in this action. Those are done by Talkdesk employees who are retained and who are there. These are fixed costs. These aren't incremental costs that would add to our performance. I'm trying to think of other costs. I think counsel mentioned plugins. I really think that it's a misquote of what I said at our earlier hearing. I recall my statement at the hearing was that if we wanted to wind this software back up and they had canceled the project, we had to wind it down and disconnect it from their system. My point is that we would have to work with them to reconnect it, do all the work that had already been done at the time. And so those costs have nothing to do with our damages here. Those are separate costs that would be related to a discovery dispute in terms of creating some kind of system for them to inspect. Those are not costs that we would have incurred if they had not breached the contract. So, there are no fixed costs. This is a very special type of agreement. It's a it's a licensing agreement. There's no incremental costs to us performing. All they have to do is access the software. And again, if they contend that there are things that should be reduced and they want to make that argument, they should have put in the evidence to do that. It's not our burden to do that for them. And even then, it's still a dispute of fact that goes before the jury. So if they have evidence they want to present on that issue, they can do that. But it's not an issue for summary judgment.
All right, anything else?
Yeah, just as to the net present value issue, again, we don't think that applies here. The full amount of the contract is due and payable. They are correct under the contract. If DataAxle does not timely pay an invoice, the payments are accelerated. That's correct. Here we issued 3 invoices in this case. They didn't timely pay any of them. Those are in the record. We produced them. We attached them to our opposition. We stated in the letter to them that the payments were being accelerated. I do think we mentioned in our complaint that the payments were accelerated. I just don't think they quoted the correct paragraph. So there is no net present value issue to calculate here, and there's nothing to say about that. And even if there were, we've cited case law in our brief that you don't have to present evidence of that in your affirmative case. That is a calculation that the court can do on the back end. I think we cite a number of cases for that proposition. They cite one case that goes the other way, but the overwhelming weight of the case law on that issue is that the court can do that at the end if it's necessary, and we don't think it's necessary here. So again, this is a very straightforward case. It's based on clear evidence. The jury is not going to be required to speculate, and it's definitely not an issue for summary judgment. Thank you.
All right, any response? You're on mute, counsel.
3 very short points. I've shown you the service and labor that they said we stopped and impaired and interfered with, and it wasn't complete. So they did have additional labor from their teams for this. That's not an incremental cost. That is an additional cost. The add-ons are set forth in the contract. We cited the section. Those are additional. That wasn't to turn it back on. He even said they're third-party software license fees to Salesforce. We're not Salesforce. Salesforce is based in California. Those are additional costs to run the platform they avoided. So again, he admitted there, and I wrote it down, we're only tracking 2 items. And what he is tracking is total gross revenue less our payments. Legally, that's not the measure of damage. Thank you, Your Honor.
All right.
May I just say one thing briefly? The Salesforce issue is just, it's incorrect. Salesforce is their system. It's DataAxle system. They would be paying fees to Salesforce. My point at the last hearing was that we would have to help connect that if we wanted to start the system back up again. All of that work had been done at the time that they breached the contract, or repudiated the contract. That had to be wound down. If we wanted to reconnect it, we'd have to do it all over again. So that's a discovery dispute. We don't pay fees to Salesforce for that. DataAxle pays those fees. So they're not a part of our damages case. Thank you.
All right. Counsel, you mentioned you obviously are the movement. So if you have a rebuttal to what counsel said, I'm going to give you final words since you are the movement and have the burden here. But then I also don't want to forget, you said there were some administrative matters you needed to bring up.
Yes, Your Honor. Thank you very much. Very shortly, counsel continues to say everything was done. He said that repeatedly, and yet in the letter that they wrote a month after the repudiation and in their counterclaim, in both written statements, they said you prevented us from completing the implementation. So regardless what counsel's telling you here on this call, on this Zoom, in their letter in response to our notice of termination and in their counterclaim, they say we prevented them from completing the implementation. So he can't change his client's judicial admissions. That's my final point there, Your Honor. Thank you.
All right. And what were the administrative matters you needed to bring up to the court's attention?
Yeah, 2 very short ones, and then one that might require a little bit of conversation. First off, Your Honor, per your order, the parties did go to mediation this past Wednesday.
Okay.
After good faith efforts on both sides, that was not successful, but we did complete your order. Secondly, Your Honor, there is a motion pending before you. It's TalkDesk's motion to reconsider a prior ruling you made. And we had stipulated, just because you had ruled on it, that we would just submit briefs and no oral argument. But I didn't
Okay.
know if you would prefer oral argument on that. But the briefing is done, and I just wanted to bring that to your attention. It was a motion to reconsider. So that's my second short one.
Okay.
Uh,
Let me just respond to the motion to reconsider. If briefing is done on that, I'm glad that you brought it up to the court. I will make sure today that it ends up on my submission docket. So obviously I have dates and times where I'm just reviewing things and going through them. And I will make sure that it ends up on one of those dockets so that we don't lose track of it here in this particular court. So I will handle it that way. If when I am reviewing the materials, I feel it is more appropriate to have oral argument on it, then I will have Mrs. Alonso to reach out to the parties and ask you all to set it for hearing. But I've made myself a note to make sure it gets set on a submission docket. It hasn't been set on one as of yet.
Very good. Thank you.
Okay.
The last one, Your Honor, is about a year ago, you entered an order that this matter would be set for trial during your 2-week term, I think starting January 4th. And for planning purposes, because there's witnesses and counsel who are out of town that are coming in, we were hoping to kind of get a feel on how full that 2-week period was. And I wanted to just share with you our availability to the extent that's has some relevancy, and that is that I was just ordered today for an oral argument in the Supreme Court on the 9th, but could be in Dallas on the 10th or 11th. And so and we have some witness availability issues, like just right at the first few days of the year, but it opens up pretty quickly after that. So I have 2 suggestions, although obviously you control your docket, Your Honor. One suggestion is maybe on the 12th, which I'm intending to be the Friday, and I think this is a week-long trial, Your Honor. Maybe we pick the jury on the 12th, and then on Monday, the 15th, just do opening statements and get right into the evidence. And I think we could certainly get it done that week. And that works with our witnesses and our counsel availability. Or if we needed to push it to your second jury trial week in January, we are quite open then. But it would be a little challenging for us to, and I want to make sure I said that date correctly. Let me make sure I'm.
Okay. I can tell you that I have the calendar open right now with respect to January.
Yeah.
And let me say 1 or 2 things. Typically, I handle pretrial the morning of trial. However, if I have a matter where, Your Honor, we've met and we think our pretrial is probably going to take a little bit longer than the morning of trial, and we don't want to irritate you because you're trying to get those jurors in here so that we can go ahead and get them seated and picked, then I do like to have those like on a Friday afternoon so that we can vet everything out. And then that way you all enter the weekend knowing, okay, she's already ruled on this, she's already ruled on that. When we arrive on Monday, we are going to just start picking our jury, and you kind of have that understanding. So that's always an option if you all want that. What I can tell you for January, especially, obviously, if you have a Supreme Court argument, that takes preference over my state court setting. So no issue there. However, I do have a special set right now. And I think that case, is it going for 3 weeks? It's a 3-week setting. It's starting on January 2nd. So it is highly unlikely, unless they settle, that you all will be reached. They've been on my docket for quite some time. It's a multi-party construction defect case, and they are starting on January 2nd, and they're going for 3 weeks.
Understood.
But what I will say, whenever you all do get reset, assuming that case does not go that especially set, what you could do is to schedule your pretrial at least 30 days in advance of your trial date, because obviously that's going to give you an indication whether or not we're going to be reached, whether or not we should bring our out-of-town people in, and what day they should come in. So when I have parties like that are trying to plan and not trying to, have a lot of expenses that should not necessarily be there because the court can't reach them, that is something that I always offer as sort of a resolution, to have your pretrial maybe at least like 30 days or at least 3 weeks in advance of trial time, so that you can understand, it is likely that we could be reached on the day she's calling us to trial.
So in light of and I'm sorry, that's the start of your year, Your Honor, with a construction dispute. I'm sure we've all tried many of those. So it sounds like January might be out for you.
Yeah.
I know we did check with our witnesses in case that was the case, and our 2 key witnesses are not available the first half of February.
Okay.
So I don't know if the second half of February is available or if we should just look at March.
It's up to you all, and if you all want to present the court with some type of a agreed motion, you can. I don't know how the second part of February looks for me, or even March. I do know how January is looking because I am going to start the new year in that 3-week trial with a whole bunch of parties, and we've already summoned a lot of jurors down here at the courtroom because they're going to need larger than a bigger panel to start the year off right. But you can talk with Mrs. Alonso about presenting that. But, we are willing to work with you all, especially when there's a lot of out-of-town people that are coming in. Another option would be too, just like you all are here on this Zoom hearing, if we have someone that gets stuck, I know, weather might be an issue. I don't know where everybody's coming in from. We could always take a witness if we can live by Zoom like this. Normally I like for everybody to agree to it, but usually the objection was, I don't have the ability to cross-examine them, but if they're live, you do have the ability to cross-examine them. So always an option if you got someone maybe coming from Chicago or somewhere else where snow might be an issue. We can certainly have the capability, and we've since have had a large upgrade here at the courthouse with our AV system, where we have not run into any issues when we've called any individuals via Zoom.
So with that, Your Honor, Maisel?
Sure.
What if all counsel of record confer and also coordinate with your staff to see available trial dates from mid-February and as soon thereafter as possible, and see what works with your schedule, our witnesses, and our traveling counsel. We all want to try it as soon as possible. And then secondly, if we may, we do have some pre-trial exchanges and motions and jury instructions that go right through Christmas. I'm wondering, I would ask you to consider, could we relieve those deadlines and tie them to the new trial date? So for example, if we set it in March, that we get those materials done in January and February, instead of, a lot of our deadlines are right around the Christmas and New Year's holidays. So that's my suggestion, but I want to do whatever you want us to do.
Well, if everybody can agree that this is looking like a plausible trial date for us, then certainly if you want to make any type of agreements that maybe go contrary to what is in the scheduling order, there should be some language in there that says, if there's an agreement by counsel, then you all can alter those dates. Just everyone needs to be on the same page.
Jason, thoughts on that?
Yeah, I think it makes sense for the parties to confer about a potential trial date that is not January 8th, because it sounds like the court is busy. And I think that we can come to an agreement for a schedule for exchanging these things in advance of that, assuming that we come to an agreement to push the trial date, which I think is going to happen anyway. Yeah,
it's highly likely you all are going to be pushed. I've had this construction case around for a while. I've had them to mediate another. They're going to trial. I do not, I'll say they're not going to settle. And then that morning, hey, we worked it out. But we're giving them all of our time for the next 3 weeks in the beginning of January.
And so would the process be, we meet and confer, kind of decide on a trial date that may work for us? We may get pushed either way, but maybe submit something to the court and reschedule the January 8th trial setting for another date?
Yes,
Okay.
yes.
Your Honor, you've indulged me quite a bit, so I appreciate that. One final question.
Uh-huh.
If that case does settle against all odds, is there a potential that, we could still maybe do the pretrial as you suggest, like Friday the 8th, and then try the case that following week?
Yeah, if it settles. If it settles, but I guess what I don't want to make sure I'm representing, you may just want to take a look on the court's trial calendar, because even though if that goes away, I don't know who's stacking up behind them.
Understood.
They of course are specially set, so they're going first, and it's an older case, but I don't know who's in the queue behind them is what I'm saying. But if you go out there and look, you can look as of today and as of right now, who's in that queue and who is lined up. But it's always a dance of musical chairs on a Friday, where I have called 35 cases to trial on Monday and end up with 4 by Monday.
Right.
So,
Very good.
and then people are a little freaked out. I was 27 on Friday. Well, okay, you're 1 today, can't help you, but you're 1. So that's just how it works around here at the courthouse. But I would take a look out there on that calendar. It's going to have all the queues lined up in terms of who has priority in my court in terms of when their case was filed.
Very good.
All right. Is there anything further? Oh, and in terms of when you all can anticipate a ruling from the court on your motion for summary judgment, I do have another hearing that is behind you all. I'm not going to schedule to say that I'll have an order out there today, but at least I'll have an order on file for you by Monday with respect to this motion for summary judgment that's been set.
Thank you, Your Honor.
Thank you.
Okay. Is there anything further?
Not for the plaintiff.
Okay.
Not
All
from
right.
us, Your Honor.
All right. Have a great weekend. Take care.
Thank
too.
you.
Thank you.
Bye.
Bye-bye. All right, good afternoon, council.
Good afternoon, Your Honor.
Good afternoon. All right, let me go ahead and call your case. We are on the record in cause number DC 23-18965, AMN Healthcare Inc. et al. Versus Robert Wolf et al. May I have the parties to briefly announce on the record? Let me know your name and who you represent.
Good afternoon, Christine Demana on behalf of plaintiffs AMN, and my colleague is with me, Zach Faircloth.
All right, thank you.
Good afternoon, Your Honor. Kirsty Zimmerman on behalf of defendants Aya Healthcare and Robert Wolf.
All right, thank you. All right, I understand there's a few things that are set today. You all have a temporary injunction hearing that was scheduled before the court or is scheduled before the court on December 14th at 11 o'clock a.m. Are you all wanting to extend the TRO? Is that correct? Or move that date or reset the TI hearing?
Yes, Your Honor, the parties agreed to an extension and submitted a joint proposed signed order to extend the TRO and schedule that hearing at the court's earliest convenience. We understand you have a trial and obtained a January 31st next available date to do that, which is in the joint proposed order.
Okay, and this is the proposed order that grants the joint motion to extend the temporary restraining order, continue the expedited discovery deadlines, and to reset your hearing. Is that correct? I just want to make sure I'm pulling the right order.
Correct, Your Honor.
Okay, all right. And did you all have, does the court need to hear argument on that? Is it an agreement or do we have an issue or you all just want to make sure that gets entered?
We have agreement, both parties have signed and we would just respectfully submit it for entry.
Okay, all righty. That's what I thought. I just wanted to make sure though, there was a few things set. So let me just take a look at the order before I release you all. All right, I have reviewed the order granting the joint motion to extend the TRO, continuation of the expedited discovery deadlines, and reset your hearing on the temporary injunction. It looks like it has been reset to January 31, 2024 at 1:30 for a 90-minute setting as agreed upon by the parties. And I'll go ahead and make sure that this gets uploaded today. Is there anything further?
Yes, Your Honor. Defendants have a motion for expedited discovery that's also set for hearing.
Okay, let me just find your motion and we'll take that up next, all right?
All right.
All right, I have it up, the defendant's motion for expedited discovery. So let me hear from counsel for the defendant on this.
Thank you, Your Honor. And I'd like to begin by thanking the court for allowing us to have this heard virtually. We understand that this is a deviation from the normal policies and procedures, and so we appreciate the consideration given the time constraints. And we also know we have about 15 minutes, so I will try to make this brief.
Okay,
May I share my screen?
yes, you should be able to share it.
So plaintiffs in this case seek immediate extreme relief in the form of a temporary injunction that will impact defendant Robert Wolf's livelihood and will also unnecessarily interfere with Aya's business. And so today, defendants are here seeking necessary limited discovery in order to investigate the basis for plaintiffs' claims and their alleged entitlement to a temporary injunction. Plaintiffs have been permitted broad requests for production and inspection of internal communications already in this matter. They've been permitted a forensic review of Robert Wolf's cell phone, and they are entitled to 4 depositions, including the deposition of one of AMN's corporate representatives. And so, as Your Honor noted during our last hearing, just as plaintiffs are entitled to expedited discovery in order to prepare for the upcoming hearing, so too are defendants. The discovery that we seek here is proportional to the discovery that is sought by plaintiffs, in that plaintiffs have been permitted to propound 6 requests for production and take 4 depositions. Here we seek 5 requests for production and 4 depositions, and we also seek 8 interrogatories. Good cause exists for granting these requests, as all of the discovery is narrowly tailored, and it's to address the factors that must be established by plaintiff in order for a temporary injunction to be issued, as well as establishing one of defendant's affirmative defenses. Indeed, Texas courts routinely allow these types of discovery vehicles, interrogatories, requests for production, and depositions in advance of TI hearings, as shown in the cases that we've cited in our brief. And so, as this court is well aware, in order for a temporary injunction to issue, plaintiff must establish they have a cause of action against the defendants, there's a probable right to the relief sought, and a probable imminent and irreparable injury without the injunction. Defendants, for their part, must present evidence in support of their affirmative defense. Here, one of our affirmative defenses is unclean hands. So we ask, what is it that AMN is claiming? They have asserted claims for breach of contract. They contend Robert Wolf has breached his employment agreement by soliciting, both directly and indirectly, a number of AMN employees, including Stephanie England and Maddie Cummings. They further allege that Robert Wolf has breached his employment agreement not to compete by working with Aya in a competing, directly related position to his role at AMN. They allege that Robert Wolf has breached his agreement not to solicit clients by virtue of his position, which purportedly necessitates his soliciting AMN clients, customers, and candidates for placement. They further allege that Robert Wolf has breached his confidentiality agreement through his employment at Aya, where he inevitably will use AMN's confidential information. And they further claim that Aya has tortiously interfered with Mr. Wolf's employment agreement and that the parties have engaged in some sort of conspiracy to breach his contract. And so the discovery that we request goes to the heart of these claims. With respect to the interrogatories we seek a list of witnesses that plaintiffs intend to call at the TI hearing. We seek the factual basis for many of their contentions, that Mr. Wolf is soliciting employees, that he is competing with AMN, that we look for identification of the clients or the prospective clients that have been solicited by Mr. Wolf or Aya, the identification of the damages and irreparable harm sustained by AMN, the identification of the confidential proprietary information that they allege Mr. Wolf has taken or will inevitably use. All of these go to the various factors that must be established. They must establish that they have a claim and that they have a right to relief. With respect to this next category, the Aya employees AMN has solicited, this goes directly to our unclean hands argument. And then finally, we seek the identification of individuals with knowledge of the DVP role that Mr. Wolf vacated. This is important because plaintiffs rely upon the declaration of Garth Weideman, who's currently the DVP at AMN. He contends that Mr. Wolf and Mr. Wolf alone was aware that he was up for this role, and that because Aya was also aware, they must have learned this information from Mr. Wolf. And so we seek information to disprove the theory that Mr. Wolf was the only individual aware that this role was open. With respect to our request for production, we seek emails, texts, and communications between Mr. Wolf, Stephanie England, Madeline Cummings, and Garth Weideman regarding outside job opportunities. Again, these are individuals that plaintiffs have identified as AMN employees who Mr. Wolf purportedly solicited. We seek emails, texts, and communications between those same individuals and AMN regarding Mr. Weideman's potential elevation, again, going to that DVP role. We seek Mr. Wolf's personnel file, internal communications regarding the review of Mr. Wolf's email account, laptop, cell phone upon his separation from employment, and emails and text messages with any AMN employee from the date of Mr. Wolf's resignation to present regarding Mr. Wolf. Now, we would note that in our motion, there is another category of documents that we previously sought that was related to AMN's recent mass layoffs. While we continue to believe that that is relevant information, we are withdrawing our request for that information for the purposes of expedited discovery. And finally, for the depositions. We seek 4 depositions, just as plaintiff seeks or is going to be taking 4 depositions. The previously identified Mr. Weideman, a corporate representative for AMN. We also seek an AMN human resources or talent acquisition representative. We believe that testimony, that individual's testimony, will be relevant to this case, as they can talk about that open DVP role, who was aware that it was open, who was aware who was up for consideration for that role. They could also testify regarding AMN's various policies and procedures as they relate to employees. And then finally, we seek the deposition of AMN's IT director. We believe this individual can testify regarding the collection of records, what they investigated, when they investigated, what they found, and just as importantly, what they didn't find prior to filing this suit. This individual can also answer questions regarding whether AMN purposely did not take certain actions and whether they believed that this was an imminent issue that necessitated immediate intervention from the court. And so we believe that all of the discovery that we seek is reasonable and necessary, to the extent that plaintiffs contend that we should not be entitled to interrogatories because they've not requested interrogatories. We would note that there was nothing precluding them from doing so. If they had wanted them, they should have asked for them. And of course, as the defendant, we will necessarily have more questions regarding the facts supporting the contentions, because we're not the ones who are asserting those contentions. And so we would ask that the court enter our proposed order with the exception of the information regarding the recent layoffs at AMN.
All right. Thank you. If you'll stop sharing your screen, counsel, I'll hear a response from you at this time.
Absolutely. Thank you, Your Honor. I'll start with the punchline. Despite defendant Aya's inexcusable failure to produce any documents in violation of this court's expedited discovery orders, which we can get to in a moment, we heard the court during our last hearing, and we put together a good faith proposal for defendants to obtain reasonable, equal, and efficient expedited discovery from AMN in advance of a TI hearing. We respectfully ask the court to enter that proposed order filed with our motion, or with our opposition rather, on Tuesday. My colleague, Ms. Zimmerman, spent a lot of time arguing that defendants should get expedited discovery, and respectfully, again, we heard the court and have tried to work with them so that we could avoid appearing in front of Your Honor to get them that equal expedited discovery. Otherwise, as Ms. Zimmerman explained in some detail, just a brief refresher to set up why we're here today, why we've been in court. Defendant Robert Wolf left my client, AMN, and is now working for its direct competitor in the healthcare staffing space, Aya, in violation of his valid and enforceable agreements with AMN. Defendant Aya, we allege, is aiding and conspiring with him to do so. We came to the court about a month ago seeking a narrow TRO related only to Mr. Wolf's employee non-solicit after Aya had stonewalled our out-of-court inquiries, and we learned that Mr. Wolf was providing AMN's confidential employee information to Aya to impermissibly solicit our employees. So as another reminder, on November 14th, after hearing from both sides, the 44th Judicial Court granted AMN a TRO against Aya and joining Mr. Wolf and Aya from impermissibly soliciting our employees. That order included very targeted document requests so the parties could move quickly, minimize further harm to AMN, and it was all supposed to be wrapped up right after Thanksgiving. It wasn't. And now we're before the court a third time on expedited discovery because of defendant's conduct. In advance of our second appearance before you on Wednesday, November 22nd, that was right before Thanksgiving, we worked with Aya to negotiate reasonable, efficient, equal, and reciprocal expedited discovery on our properly noticed motion related to AMN's remaining non-compete, client non-solicit, and confidential information claims. We have been acting conservatively in respect of the court's time and resources in seeking expedited discovery on those claims before requesting a TRO or a TI. So this expedited discovery is not currently part of the set TI hearing on the employee non-solicit, just to be clear. Despite our recent and repeated attempts to compromise, defendants didn't meaningfully engage on any of that expedited discovery before our last hearing until Your Honor was taking the bench that next morning, and the court entered AMN's properly noticed order for expedited discovery. Since then, defendants have done little to nothing in the face of the court's orders, despite our agreeing to extend time for their productions and agreeing to extend the TI hearing twice, which we just did again this morning. Last Friday, rather than comply with the court's discovery orders and deadlines, defendant Aya stonewalled and objected to the court's order via an email to counsel and has yet to produce any documents. Yesterday, defendant served objections on AMN's court-ordered corporate representative deposition, apparently refusing to produce a witness on any notice topic that AMN provided. And there's another deadline now looming today for defendants to produce discovery. We're pessimistic. Aya will produce anything still. And so we were forced to file this morning a motion asking the court to enforce its orders, which is not set for hearing today, but it is on the docket, should Your Honor be looking at it. But nonetheless, AMN has continued to negotiate with defendants on their request for expedited discovery. Again, we heard Your Honor during our last hearing that you'd award Aya reasonable reciprocal discovery in advance of any TI hearing, and we've tried our best to work with defendants to accomplish that. So we submitted a proposed order on defendants' motion, and we have negotiated this and sent a few compromises to defendants for 6 document requests, just like us, reciprocal depositions, and it's all tailored to be equal and efficient. A quick word on the depositions. They say we've received 4 depositions and they ask for 4 depositions. I think we're engaging in a little bit of semantics and there's some room there. They essentially request 3 corporate representative depositions, a corporate representative deposition, an HR deposition, and an IT director deposition, but they want corporate testimony on all of that, which we assume would be a corporate representative deposition, and we would produce witnesses who are educated to opine on those. So I think the depositions are a little bit semantic between the parties, but that's just a note as far as reciprocity. So despite our proposed order and our willingness to give them, exactly what we have and be efficient, they want to engage in wide-ranging, irrelevant, and expanded discovery. There's a reason they pulled down a request for quote-unquote mass layoffs that have nothing to do with this case. They're asking for a bunch of interrogatories. Again, we don't have those, and we're asking the court not to permit those because we are trying to be efficient, targeted, tailored. That's why AMN has proceeded cautiously. Tellingly, on Ms. Zimmerman's slides, most of the information that they're asking for in those interrogatories are uniquely within their possession. So they're asking for the identity of clients Aya and Wolf have solicited, damages that we have incurred from that solicitation, which again, they've given us no information on and is uniquely in their possession. So respectfully, we're here again. We're a little bit frustrated to be here again. And in front of the court on expedited discovery that, again, we have agreed to give to defendants. Our efficient and conservative conduct continues. We're happy to answer any questions about why any and each of defendants' requests is otherwise improper for the court's convenience, though we respect that Your Honor has read our submissions and heard argument. But at bottom, we respectfully request that the court enter plaintiff's proposed order so we can all move on, get this done, and efficiently proceed to avoid further harm to our client. We also would say, should the court be inclined to want to look at a further compromise, we would respectfully request entry of the last offer that we sent to plaintiffs yesterday. And I'm happy to pull it up on my screen that attempts a further compromise again with the defendants. Thank you.
All right, counsel response.
Thank you, Your Honor. Again, I'm trying to be mindful of your time. 2 points. One, while we wholly disagree with plaintiff's characterization of defendants' attempts to comply with this court's order, frankly, that's not before the court today. It's inaccurate to say we've done nothing. We have, in fact, done quite a bit. We have timely imaged Mr. Wolf's cell phone. The parties have gone round and round and round to agree upon a protocol, which was not entered until 3 days ago. We have a discovery vendor who is working to pull information now that we have an agreed protocol. We timely produced documents to the extent that they even existed in response to some of the categories of discovery, and we intend to timely comply today with additional requests for production. And so to say we've done nothing is just frankly not accurate. With respect to the parties' attempts to avoid coming here today, yes, I agree that the parties worked to agree upon expedited discovery on behalf of defendants. Unfortunately, The discovery that plaintiffs would agree to was extremely limited. It included no interrogatories, only 2 depositions, and there were several categories of information they simply were not willing to share with us. And so while it sounds nice to say that plaintiffs have worked with us, the fact of the matter is they've worked with us they've only agreed to do things on their terms, and they've not really conceded that there are certain categories of information that we frankly need in order to defend against the request for the temporary injunction. And so again, we would ask that the court enter our order as proposed.
All right. With respect to the defendant's motion for expedited discovery, I've pulled the 2 orders. I will take a look at your motion and the opposition. I will enter an order today with respect to the defendant's expedited discovery. I intend to grant it. Let me just take a look at what has been filed with the court. And I will sign an order today and make sure that gets uploaded today so that everyone understands the discovery that has been ordered pursuant to the court's order.
Thank
All
you.
right. Are there any questions for me?
None from defendant.
All right. Then I think that concludes our hearing. I'll make sure your other order is uploaded with respect to the temporary injunction date. And as I mentioned, I will have another order on file with respect to the defendant's motion for expedited discovery.
Thank you, Your Honor.
Okay. All right. Thank you so much. Take care.